Today, Attorney General Merrick Garland was asked about Special Prosecutor Jack Smith's indictment of Donald Trump.
Republicans in Congress, some of them have been talking about weaponization of the justice system. When did you find out the special counsel was headed down this track? And why did you choose not to stop him, as was in your power?
So, as you know, I can't talk about particulars of this or any other ongoing criminal matter. As I said when I appointed Mr. Smith, I did so because it underscores the Justice Department's commitment to both independence and accountability. Mr. Smith is a veteran career prosecutor. He has assembled a group of experienced and talented prosecutors and agents who share his commitment to integrity and the rule of law. Any questions about this matter will have to be answered by their filings in court.
Joining us now is Democratic Senator Sheldon Whitehouse of Rhode Island. He's a member of the Senate Judiciary Committee, the Senate Finance Committee, and chair of the Senate Budget Committee. Thank you very much for joining us tonight, Senator. First of all, your reaction to the way Merrick Garland handled that. He's basically taking the position they will speak only through their filings in court.
That is the customary Department of Justice position. It was the right position for him to take. And as Attorney General, he only has the responsibility to select and appoint a special counsel, see to it that they have resources and staff necessary to do their jobs, and then police the guardrails of compliance with Justice Department policies and regulations and procedures.
So we have a new question that you might want to consider on your list for Senate confirmation hearings, especially for district court judges. This has never come up before, of course, so it hasn't really been a question before, but that question would be to a nominee for the district court: will you recuse yourself from a criminal trial involving the president who appointed you? Does that seem like something we should be asking from now on?
God, let's please pray that we don't ever need to ask that question again, so that we don't have another situation of a president engaged in conduct that causes him to be indicted for criminality. Please, let's hope this is a one-off. But to your point, there's nothing wrong with the question, other than that I hope we never have to ask it.
The situation we're seeing now has been described this way by NYU law professor Stephen Gillers, who's as you know, an expert on judicial matters. And what he's saying is that the rule on recusal says the rule says that the judge should not sit when we can't fairly ask the public to trust what the judge does. And Professor Gillers maintains this is one of those situations that Judge Cannon really must recuse.
Well, there's the proper recusal rule, and then within the 11th Circuit, there's also a sort of hygienic proposal that allows judges to be reassigned if it doesn't look like they're the right judge for a particular matter, without having to go all the way to full-on recusal. But one way or the other, this is a decision that's going to have to be made by Special Counsel Smith before he gets to trial, because once that jury is impaneled and sworn, jeopardy attaches. And now the rulings of this judge, potentially dispositive rulings dismissing the case, are protected by double jeopardy, and the government doesn't get to appeal even if they're flagrantly wrong. So there's a time clock that's running for Jack Smith to make whatever move he feels he needs to make regarding recusal.
Senator Whitehouse, we have to squeeze in a commercial break. Can you please stay with us? I want to get to the hearing you had today about the ethics of the Supreme Court. We'll be right back with Senator Sheldon Whitehouse.